Welcome. My name is Warren Lindsay, and I'm currently the chair of the Florida Bar Criminal Law Section. As an introduction, the Criminal Law Section of the Florida Bar is comprised of over 2,100 state and federal criminal law practitioners, and that includes attorneys that are practicing as judges, prosecutors, defense lawyers, and law professors, and those in academia. The goal or the purpose of the Criminal Law Section is to promote a fair, just, and efficient criminal justice system for all of our citizens, and those goals are the goals that we strive to accomplish through the programs and projects of the section. Regardless of your practice, we would welcome you as a member of the Criminal Law Section if you are not already a member. You get incredibly good value for only $25 a year dues. We present numerous very relevant and cutting-edge seminars that can help you in practical nuts and bolts ways of your practice. We also have many committees that you are welcome to become involved in. We provide frequent case law updates, and we also provide opportunities for networking and just for referral sources among attorneys throughout the state. Now to our seminar. Effective May of 2016, Florida Rule of Criminal Procedure 3.113 requires that before an attorney may participate as counsel of record in an adult felony case, which includes post-conviction cases, the attorney must complete a Florida Bar-approved 2-credit CLE course of at least 100 minutes covering the legal and ethical obligations of criminal discovery, including Rule 3.220, and including the principles established by the Brady v. Maryland case, which everyone is familiar with, and the Giglio versus United States case, which you all are already familiar with. The Criminal Law Section is very pleased and honored to provide free of charge 2 outstanding options to comply with Rule 3.113 and to satisfy that requirement. One of them is attendance at the seminar that you are about to watch today, which is a seminar which includes Ethics of Discovery, Florida Rule of Criminal Procedure 3.220, Brady and Giglio discovery obligations. The second way that you can satisfy that obligation is by attending another seminar, which you have access to through the portal of the Criminal Law Section website, and that is presented by the Florida Prosecuting Attorneys Association, and it is entitled Ethics of Discovery, Rule 3.220, and Brady and Giglio. Again, you can satisfy the obligation by attending that seminar through a link by our section's website. Both are very good seminars, and you can attend both of them, get CLE credit for both of them, and maybe receive a little bit different perspective by one presenting by the Criminal Law Section and one presented by the Florida Prosecuting Attorneys Association. Now to today's program. I am honored to introduce the presenter of the seminar today, and that is Pinellas County Attorney Dennis DeFlaming. Dennis may not even really need that much of an introduction because of the outstanding reputation that he has developed over literally decades of practice. And many of you have probably already had the honor and privilege of watching him in different seminars that he's presented throughout the state over the last 30 years or so. Dennis received his undergraduate degree from Ohio State University and his law degree from Stetson University. He was a prosecutor in the Sixth Circuit for 3 years before starting his own private practice in about 1975. Among the many significant positions that Dennis has held throughout his career is past president of the Florida Association of Criminal Defense Lawyers. He also has served as past chair of the Criminal Law Section of the Florida Bar. And of course, Dennis is board certified in criminal trial law since 1988. He was among the first lawyers in Florida to become board certified. We hope that you enjoy and find today's seminar presentation helpful in your practice. And again, we would welcome you to join the Criminal Law Section if you're not already a member. Thank you very much.
Hi, this is Dennis DeFlaming speaking. I am giving you the seminar on the compliance requirement of Rule 3.113, and I'm broadcasting or taping, I should say, from my law office at 1101 Turner Street in Clearwater, Florida. The Florida Bar, as well as the Supreme Court, has required this seminar, and I'm going to be able to explain that to you in a moment, but it has to go for 100 minutes in length in order to receive your compliance with the rule. So in a minute, we're going to go to my PowerPoint. You're not going to see me again until the very end of this. I'll go ahead and sign off, congratulate you about being in compliance, tell you to go ahead and register with the Florida Bar that you are now in compliance with Rule 3.113. So we might as well get started. We got 100 minutes to spend together, so let's go ahead and see where we're going to go. All right, this is the name of the required course. It's discovery requirements and obligations under Rule 3.220. That's our discovery rule. And understanding Brady versus Maryland and Giglio versus United States. The course number you can write down, and you do have to go ahead and tell the Florida Bar what the course number was that you listened to. And it is 180. Actually, that is not correct. It is not 180. The compliance I will give you at the end of this presentation. The CLE credits, we have general 2 hours of CLE credits. Ethics are 1 hour. Certification, you get 2 hours of credit for appellate law, criminal trial law, and juvenile law. All right, Florida Rule of Criminal Procedure 3.113, effective May 16th of 2016, Rule 3.113, entitled Minimum Standards for Attorneys in Felony Cases will be required. It reads, quote, before an attorney may participate as counsel of record in the circuit court for any adult felony case, okay, circuit court adult felony case, not juvenile and not misdemeanor, but it does include post-conviction proceedings before the trial court. The attorney must complete a course approved by the Florida Bar, which this is, for continuing legal education, credits of at least 100 minutes and covering the legal and ethical obligations of discovery in a criminal case, including the requirements of 3.220 and the principles established in Brady versus Maryland and Giglio versus the United States. Florida is the only state in the United States of America that requires this course for a lawyer to be able to practice law in adult felony court or post-conviction proceedings. And the question is, why Florida? Why us? The appeals and post-conviction claims, the courts were seeing some disturbing trends in discovery, Brady and Giglio violations. They were having convictions reversed because defense lawyers were finding out after the conviction that information was withheld, it was hidden, and that it was material in nature, or there were Giglio violations. And the Florida Supreme Court ended up saying, you know what, maybe we need some education on this. And so the Innocence Project pushed it heavily, and ultimately the Florida Supreme Court approved the rule. And here's just some things. Former prosecutor in a terror case charged with hiding evidence. This is the kind of thing that the courts were talking about. Wrongly convicted man receives money for a DNA clearance of his conviction. And on the left of the screen, it says 2 city police officers fabricated and withheld evidence in the case. And the oath in the Florida Bar, this has been added, at least since I took my oath, and it says an additional paragraph to opposing parties and their counsel. I pledge fairness, integrity, and civility not only in court, but in all written and oral communications. And so the following of these cases of Brady versus Maryland and Giglio versus the United States and the discovery obligations kind of tell us that we've got to play fair. Okay, let's go on over 3.220 and some of the highlights of it. And it says, how and when do discovery obligations begin? Rule 3.220A states, quote, after the filing of the charging document, that's after the filing of the document, not just after arrest, a defendant may elect to participate in the discovery process provided by these rules, including the taking of discovery depositions by filing with the court and serving on the prosecuting attorney a, quote, notice of discovery, unquote, which shall bind both the prosecution and defendant to all discovery procedures contained within these rules. We're going to go over both the obligations of the prosecution and obligations of the defense if they choose to engage in discovery. How do you get out of the rule? How do you circumvent it? You really can't. This rule may not be circumvented by the defendant filing a public records request under Chapter 119 Florida statutes, which are non-exempt as a result of a co-defendant's participation in discovery. Even in cases where a defendant knowingly or purposely shares in discovery obtained by a co-defendant, will the court deem participation in discovery. So if a co-defendant gets discovery and you run over to that defense lawyer's office and say, let me look at yours, I don't want to file for discovery, you have elected to engage in discovery and have reciprocal obligations. Time limits. Within 15 days after service of the notice of discovery, the prosecutor shall serve a written discovery exhibit, which shall disclose to the defendant and allow him to inspect, copy, test, and photograph the following. That 15 days is pretty loose. I've never seen a judge grant a motion to compel on the 16th day because the prosecutor has not given all the discovery required. Prosecutor's obligations, a list of the names and addresses of all persons known to the prosecutor to have information that may be relevant to any offense charge or any defense thereto, or to any similar fact evidence to be presented at trial. In other words, anything that they know which tends to convict the defendant or support a valid defense or any similar fact evidence under the Williams rule have to be given within that time period. Number two, category A through C witnesses have to be provided. A, witnesses are deposed without leave of court. B, good cause needs to be shown. C, no deposition unless the court determines a witness should be in another category. The defendant may depose any witness listed by a co-defendant who may testify at joint trial or hearing. Choosing the wrong category. Prosecutors have to be careful. They may say it's a B category or a C category, and it's really an A. In Ward versus State, the 4th District ruled in 2015 that the state must designate in discovery the expert status of a police officer who will testify as an expert witness as a Category A witness. The state's reference to listed police officers in portion of exhibit relating to reports or statements of experts was insufficient to comply with its discovery obligation regarding the designation of a detective as an expert witness. So when in doubt, make them available for deposition. Number three, the statement of any person whose name is furnished in compliance with the rules. This includes a written statement made by the person and signed or otherwise adopted or approved by the person, and also includes any statement of any kind or manner made by the person and written or recorded or summarized in any writing or recording. It is specifically intended to include all police and investigative reports of any kind prepared for, in or in connection with the case, but shall not include the notes from which those reports were complied. Now, I put a note, watch out for Brady, because there are times when you are entitled to those notes, even though this rule says you're not. We'll cover that in a little bit. Number four, any written or recorded statements and the substance of any oral statements made by the defendant, including a copy of any statements contained in police reports or report summaries, together with the name and address of each witness to the statements. 5, any written or recorded statements and the substance of any oral statements made by a co-defendant. 6, those portions of recorded grand jury minutes that contain the testimony of the defendant. 7, whether the state has any material or information that has been provided by a confidential informant. And we're going to go over the confidential informant rule in paragraph 13 coming up. Number 8, whether there has been any electronic surveillance, including wiretapping of the premises of the defendant or of conversations to which the defendant was a party, and any documents relating to that, thereto. Number 9, whether there has been any search and seizure, any documents relating to that. Number 10, reports or statement of experts made in connection with a particular case, including the results of any mental examinations and scientific tests, experiments, or comparisons. The state must disclose results of hair analysis, not just that an analysis was done. Now, there's a new rule that says that the defense, well, we're going to go over the defense's obligations in a minute, but that's the state's obligation, is reports or statements made of experts, regardless of the outcome of those reports. Number 11, any tangible papers or objects that the prosecuting attorney intends to use in the hearing or trial and that were not obtained from or did not belong to the defendant. 12, any tangible papers, objects, or substances in the possession of law enforcement that could be tested for DNA. When it comes to providing discovery, the state need only tell, not provide the defense notice of the existence of tangible discovery. So if they say they have a tape recording, the state cannot yell and scream that they didn't mail the tape recording to them. If they can make it available to you, you got to get up, go down there and listen to it. If they're willing to make a copy, so be it. But they just need to tell you it exists, but not necessarily provide it. In McKenzie versus State, the Florida Supreme Court in 2014 said where the state lists electronic surveillance of conversations in its discovery exhibit after the defendant elects to engage in discovery, the defendant is placed on notice that such exists and cannot complain that he was not provided it where he took no steps to acquire the recordings. Jules versus State, 4th District, 2015. Defendant failed to establish a discovery violation prior to and during a trial that no money had been recovered from the search of the defendant before the state offered evidence that money had been recovered from the defendant's jeans pocket. The state disclosed laboratory reports and discovery which listed defendant's jeans and advised to, quote, see property receipt for description of the items that were discovered in the pocket of the jeans. Guess what? It was money. Property receipts that were in the state's possession were turned over to the defendant, and the defendant had the opportunity to review the documents indicating the presence of the money, and the defense never moved to compel the production. So, lesson learned, if they tell you they got it, go look at it, defense lawyers. Testifying informants, I put relatively new. It's not that new now. It's probably over 5 or 6, 7 years old, but it's relatively new to the rule itself. And it's in number 13. Whether the state has any material or information that has been previously provided by an informant witness, including, let me stop right here. There were a lot of problems with these jailhouse snitches and tremendous problems with them. And they were testifying for a deal. They were testifying because they were professional snitchers and so forth. So the Supreme Court came up with this rule. And this is what it says in A, the substance of any statement allegedly made by the defendant about which the informant witness may testify. 2, a summary of the criminal history record of the informant witness. C, the time and place under which the defendant's alleged statement was made. Was it done in the jail? Was it made on the phone? The circumstances have to be disclosed. D, whether the informant witness has received or expects to receive anything in exchange for his or her testimony. Not only get out of jail free, but also a transfer to a different institution, better commissary, conjugal visits, anything in exchange for his testimony. And E, the informant witness's prior history of cooperation in return for any benefit as known to the prosecutor. E is probably the most sticky one involved in this because this person may have given cooperation in many different counties in the state and sometimes different states in the United States. And so you really need to the defense needs to file a motion to find out what his prior history of cooperation is. Don't just take the word of the informant. Find out where he lived and see that the prosecutor provides any information that he was a cooperating witness to any other police department anywhere. 14, if the court determines in camera that any police or investigative report contains sensitive information into related or other crimes or criminal activities, and the disclosure of the contents may seriously impair law enforcement, the court may prohibit or partially restrict the disclosure. This is something the prosecutor would engage in if he believes that to be the case. Case law example, Demings is a sheriff, and it was decided by the 5th District in 2014. The trial court granted an order requiring the sheriff to disclose an operation plan which is intended to identify violations of the Computer Pornography and Child Exploitation Prevention Act. Sheriff was not made a part of the hearing, just state attorney and the defense. A motion for rehearing was filed by the sheriff, however, when he found out about it being granted, where an in-camera inspection was requested. The court denied the request. The sheriff appealed by requesting a certiorari review. The district court ruled the trial court should have granted an in-camera inspection of the information requested by the defense to determine materiality, as well as whether the sensitive law enforcement information may be exempt from disclosure under this particular rule. I mean, the sheriff doesn't want the public or the defense to know how they're putting together these kinds of cases. And so they did say it fell within this particular rule of protection. 15, the court may prohibit the state from introducing evidence of any foregoing material not disclosed to maintain fairness. That's a Richardson inquiry. 16, as soon as practical after the filing of the charging document, the prosecutor shall disclose to the defendant any material information within the state's position of control that tends to negate the guilt of the defendant as to any offense charge, and then this is my underlining, regardless of whether the defendant has incurred reciprocal discovery obligations. In other words, Brady versus Maryland kicks in regardless of the discovery rule. Disclosure to the prosecution. This is what has to be disclosed to the prosecution. And discovery does not have to be elected in this situation. After the filing of the charging document and subject to constitutional limitations, the court may require the defendant to 1, appear in a lineup, 2, speak for identification by witnesses to an offense, 3, be fingerprinted, 4, pose for photographs not involving reenactment of the scene, 5, try on articles of clothing, 6, permit the taking of specimens of material under the defendant's fingernails, 7, permit the taking of samples of the defendant's blood, hair, and other materials of the defendant's body that involves no unreasonable intrusion thereof. By that, they mean you cannot surgically go in and look at a person's kidney to find out whether or not it happens to be the one of the accused. Number 8, provide specimens of the defendant's handwriting. 9, submit to a reasonable physical or medical inspection of the defendant's body. For example, if somebody has tattoos and they're on his or her inner thigh in a place where normally people wouldn't see it, they can get a court order to have a physical examination to determine the presence of those tattoos. Now let's talk about the defendant's obligations. Within 15 days after receipt of the defendant, receipt by the defendant of the discovery exhibit furnished by the prosecutor, the defendant shall furnish a witness list of the names and addresses of all witnesses. And again, this is my underlying and so forth, whom the defendant expects to call as a witness at the trial or hearing. So that's different from the state. The obligation of the defendant is who the defendant expects to call, not who they learned about, as is required by the prosecutor. Also, the 15-day rule is really almost never adhered to because a defendant doesn't know who he's going to expect only 15 days after receipt of the discovery furnished by the state. They have to take depositions, they have to make determinations, and so forth. So it says 15 days, but don't count on it. 2, within 15 days after receipt, actually it's of the prosecutor's discovery exhibit, the defendant shall serve a written discovery exhibit which shall disclose and permit the prosecutor to inspect the following information and material that is in the defendant's possession or control. A, the statement of any person listed by the defendant. Okay, you list them, they're entitled to it, other than, of course, the defendant himself. 2, or B, reports or statement of experts that the defendant intends to use as witness or trial. That's a new wording as of May of 2018. It used to be the state had to provide it regardless of whether or not they were going to call them. That's now been changed. And that's made in connection with a particular case, including results of physical or mental examinations and of scientific tests, experiments, or comparisons. There was a second district case in 2013 that said that the defense had to turn it over regardless of whether or not they were going to call this expert, because that's the way the rule read, and the Supreme Court has now changed the rule. C, any tangible papers or objects that the defendant intends to use in the hearing or trial. Getting out of discovery, if the prosecutor files a motion for a protective order, it will automatically stay the times provided for in the rule. If the protective order is granted, the defendant may, within 2 days thereafter, or any time before the prosecutor furnishes the information or material that is the subject of the motion for the protective order, withdraw the defendant's notice of discovery and not be required to furnish reciprocal discovery. So if the state decides to move for a protective order because they don't think there should be things that are turned over, but they have already provided the rest of discovery, there's an issue, as it says in the bottom of this question. What if the defense has learned material from the written discovery provided so far? And then he elects to come out of discovery because the prosecutor has moved for this protective order to withhold certain information. Be careful, prosecutors, about this, because I think what it's saying is the defense can read what you've sent and then still get out of discovery because you were successful in a protective order. Restricting disclosure. The court, on its own initiative or on motion of counsel, shall deny or partially restrict disclosures authorized by this rule if it finds there is a substantial risk to any person of physical harm, intimidation, bribery, economic reprisals, or unnecessary annoyance or embarrassment resulting from the disclosure that outweighs any usefulness of the disclosure to either party. So basically, the state will provide this in camera to the court and argue that it shouldn't be turned over because there's a substantial risk, physical harm, bribery, intimidation, or what have you. Matters not subject to discovery. Work product. Disclosure shall not be required of legal research or of records, correspondence, reports, or memoranda to the extent they contain the opinions, theories, or conclusions of the prosecuting or defense attorney or members of their legal staff. I wrote down the word exception with a question mark at the bottom because there might be an exception to work product. And that exception is, you got it, that's right, is Brady. If anything contained in those memoranda, which normally is work product, contains Brady material, which we're going to cover later in this seminar, then it has to be turned over. Depositions, 3.220H discusses the taking of depositions. No deposition shall be taken in a case in which the defendant is charged only with a misdemeanor or a criminal traffic offense when all other discovery provided in the rule has been complied with, unless good cause can be shown to the trial court. Again, I underline that. So if there's a particular reason, it's not in the police reports, the person is an important witness, there's no statement that he made in writing, you might need to take a deposition. However, this prohibition against the taking of misdemeanor depositions shall not be applicable if, following the furnishing of discovery by the defendant, the state then takes the statement of a listed defense witness pursuant to Section 2704 Florida statutes. In other words, the defense gives the prosecutor a list of witnesses in a misdemeanor case. The prosecutor says, gee, I'd like to talk to these people, so I'm going to issue them a state attorney investigation, subpoena, so that they can come in and I'll ask them, what do you know about this case? If they do that, then depositions are automatically allowed. Depositions of children under the age of 18 shall be videotaped unless otherwise ordered by the court. It used to be 16, now it's 18. Defendants shall not be present, however good cause may allow it if A, the need is present for effective discovery, and B, there is no intimidating effect on the witness. Let me spend a moment on that. We can all understand in a rape case why the rules would be that the defendant could not be in a small deposition room sitting within feet of an alleged rape victim. We understand that, and there's no motion that can be filed where the court's going to allow the defendant to be present. But there are offenses where it fits within A and B. And let's give an example. If you had a complicated securities case and you really didn't know much about securities at all, but your client did, So you need to have him there so you can show him documents that are brought to the deposition or ask him questions because it's confusing to you. So the need is present for an effective discovery. And B, there's no intimidating effect on the witness. You know, having somebody testify for the state about a security is not going to be intimidated by a defendant sitting there listening to the testimony. So you may want to consider using that particular paragraph. Next, telephonic depositions. This surprises some people. When agreed by the parties and the witness, do not have to be sworn. The rule provides they can, however, be used for impeachment purposes. So, you take these telephone depositions of somebody out of state, and it gets clumsy when you say, okay, raise your right hand. Do you swear to tell the truth? Well, if it's not a Zoom or a video deposition, how do you know his hand's up? How do you know he's not crossing his fingers? So you don't have to swear him in. A lot of people think you have to send them an oath and they sign it and send it back. You don't have to do that. And the rule provides specifically that the deposition can be used for impeachment, which is exactly what the lawyer wants to do. So that can be used both by prosecution and defense successfully. 3.220I reads, neither the counsel for the parties nor other prosecution or defense personnel shall advise persons having relevant material or information, of course, except the defendant, to refrain from discussing the case with opposing counsel or showing opposing counsel any relevant material, nor shall they otherwise impede opposing counsel's investigation of the case. This particular rule is unknown, if not followed by both prosecution and defense. Both sides say to their witnesses, now don't talk to the other side. Don't say anything to them. If they come up, don't talk to them at all. And this rule says that neither side can do that, okay, except, of course, the request to talk to the defendant. And that it's a violation of the rule if you tell your witnesses under no circumstances can they talk to the other side. Don't do it. Now, can they say if somebody approaches you and they want to talk to you, tell them that you would like me to be present? Yeah, I think you can do that. But a blanket do not talk to anybody is a violation of this rule. Either side may talk to the other witnesses. I had to bounce that one on there. There, I'm going to do one more time. Okay. Catch-all. On a showing of materiality, the court may require such other discovery to the parties as justice may require. So you can't find it in the rules, and it's material to what you need. Okay, there's your catch-all statement. Sanctions. What do you do if you don't comply? If at any time during the course of the proceedings it's brought to the attention of the court that a party has failed to comply with an applicable discovery rule or with an order issued pursuant to an applicable discovery rule, the court may order the party to comply with the discovery or inspection of the materials not previously disclosed or produced, grant a continuance, grant a mistrial, prohibit the party from calling a witness not disclosed or introducing into evidence the material not disclosed, or enter such other order as it deems just under the circumstances. And this is sort of, again, the Richardson inquiry and the Richardson rule. There's a problem. It's really not equal to both the state and the defense. A lot of case law that says if the court strikes a defense witness because it was not provided in discovery and it's material, and the trial goes forward, there could be a due process violation. Whereas not necessarily so against the prosecution. That's just life, I suppose. Sanction of striking a witness, State versus Sullivan, 2nd District, 2015. The trial court erred when it imposed the severe sanction of prohibiting a party from calling a witness without considering whether the potential prejudice to the non-offending party could be overcome with a less severe sanction, like a continuance, or like the ability of the person to go out and depose the witness in the hallway or talk to the person ahead of time. But there can be error found. The sanction of eliminating evidence, Bryant versus State, 4th District, 2016. A 5-week recess for the defendant to conduct DNA testing cured any prejudice resulting from the state's mid-trial disclosure of pants containing DNA, evidence linking defendant to the murder, even though the defendant insinuating during his opening statement there was no DNA linking him to the murder. The trial court allowed both parties to give a second opening statement after the recess which allowed both sides to take into account new evidence from both experts. The defendant rejected trial court's repeated offers to grant a mistrial. I think that last sentence sort of makes it a little bit more understanding, because to have a 5-week recess and make somebody give another opening is rather severe. But the judge did give the defense, said, you want a mistrial? You can have a mistrial. We'll do this another time. And the defendant said, I don't want a mistrial. So he goes, okay, I'll give you the recess. 2, a willful violation may result in sanctions. They may include, but are not limited to, contempt proceedings, as well as the assessment of costs incurred by the opposing party when appropriate. This is rarely done. I've never seen anybody held in contempt. I think the only time contempt would ever be used is if the judge specifically, on 2 or 3 occasions, told the one side to comply and they still did not do it. But if 2 or 3 times it happens and the judge does not allow contempt, if you're in private practice, you may want to file for the assessment of attorney's fees because of having to come to court 2 or 3 times in order to make the other side comply with discovery. Okay, that was 3.220. And now we're going to talk about Brady and Giglio. Okay. First off, you need to know who John Leo Brady was. Now, I've been practicing law for 48 years. I know I read Brady in law school. Might have read it when I was a prosecutor or as a defense lawyer. I don't remember. But when I agreed to teach this course, I figured, I think I better read up about John Leo Brady. And I'm going to tell you stuff that probably you don't know either. So we'll do a little quiz. Brady was a defendant being prosecuted in the state of Maryland for robbery, home burglary, commercial burglary, murder, or arson. I've had some people say it's number 3, commercial burglary. But no, that's Gideon. Remember Gideon broke into a pool hall, allegedly? So the answer to this one is number 4, murder. 2, the Brady decision was based on 1, a sentencing issue. 2, an issue that would have exonerated Brady. 3, an error that resulted in the reversal of Brady's conviction by the United States Supreme Court. Most people say 3. Some people say 2. The answer, believe it or not, is 1. This was Brady. Brady was on trial for first-degree murder in the state of Maryland, along with a co-defendant named Boblet. Brady's lawyer conceded guilt to the jury. The evidence was quite overwhelming, but argued that his life should be spared from execution. Brady was convicted and sentenced to death. After all appeals and post-conviction matters were concluded, Brady learned that the state had withheld a statement made by his co-defendant Boblet, which, although implicating Brady in the crime, excluded him as the actual killer. Brady argued that this statement violated due process by not being turned over to his defense team. His position was, had the jury learned that he did not do the actual killing, the jury would have voted to spare his life. In 1963, the U.S. Supreme Court agreed in Brady versus Maryland and reversed for a new sentencing hearing. Brady was a sentencing hearing case, and that surprises most lawyers. There are common misconceptions of Brady obligations. Number 1, a prosecutor only has to turn over exonerating evidence. Okay? They do, but that's not all. 2, only Brady evidence in the hands of the prosecution has to be turned over to the defense. Not so. If it's in the hands of law enforcement, the information is deemed to be in the possession of the state and the prosecution. 3, evidence that falls under Brady can be given to the defense the day of trial. No. It has to be given at a reasonable time so that it can be looked at, investigated, explored. 4, prosecutors don't have to look for Brady material. They only have to turn it over if they come across it. I've had quite a few prosecutors say, no, if I learn about Brady, I turn it over. I turn it over. Well, what you're going to learn as we go on is there's an obligation not only to turn it over when you get it, but to go out and look for it. Number 5, prosecutors never have to turn over their handwritten notes. Now, that might be a shocker to a lot of people, but I'm going to tell you about a Florida Supreme Court case where there was a reversal because the prosecutor did not turn over his handwritten notes that contained Brady material. Brady covers more. Prosecution must turn over to the defense evidence that exonerates, yes. Evidence that materially impeaches any fact or witness. Evidence that would lessen the punishment comes under Brady. Any evidence that supports a valid defense to the charge. That's Brady, as well as 3.220 discovery obligations. 5, any material exculpatory evidence defined as if there's a reasonable probability that the conviction or sentence would have been different had these materials been disclosed. So the exculpatory information needs to be turned over. What's the motive behind Brady? What did the United States Supreme Court say? And this is found in the United States versus Bagley, which is another hugely important case, right along with Brady. It came after Brady, of course, but it really discussed the obligations under Brady as far as the government is concerned. But it says, by requiring the prosecutor to assist the defense in making its case. Wow. By requiring the prosecutor to assist the defense in making its case, the Brady rule represents a limited departure from a pure adversary model. This is because the prosecutor's role transcends that of an adversary. The prosecutor is the representative not of an ordinary party to a controversy, but of a sovereignty, whose interest in a criminal prosecution is not that it shall win a case, but that justice shall be done. Powerful statement, very, very powerful statement, telling the government, you're the Goliath here. You have to assist the defense in making its case. Kiles versus Whitley, another giant, along with Brady. It holds the individual prosecutor has a duty to learn of any favorable evidence known to the others acting on the government's behalf in the case, including the police. Notice it doesn't say has a duty to turn over if they learn. It says they have a duty to learn of any favorable evidence, which means they have to go out and look for it and assist the defense in making its case. The Florida Supreme Court agrees. To comply with Brady, the individual prosecutor has a duty to learn of any favorable evidence and to disclose that evidence to the defense. Knight versus State, 2017. All right, how do you get Brady? It's a little naive to say, well, I'm gonna rely on my prosecutor to go out and learn and find all Brady and turn it over. You're awful naive if you believe that. Because what Bagley said was the more specifically the defense requests certain evidence, thus putting the prosecutor on notice of its value, the more reasonable it is for the defense to assume from the non-disclosure that the evidence does not exist and to make pretrial and trial decisions on the basis of this assumption. The reviewing court may consider directly any adverse effect that the prosecutor's failure to respond may have had on the preparation or presentation of the defendant's case. So if you ask for it and you tell them to look for it and they end up saying it doesn't exist, you can assume from the non-disclosure and to make just pretrial and trial decisions, you can rely on that statement. But also, if you find out later that you made the request, they say they don't have it, and the police do, or the prosecutor does, then Brady's going to raise its head and reverse the case. And Bagley said, when the prosecutor receives a specific and relevant request, the failure to make any response is seldom, if ever, excusable. So you have to file that motion. The motion just is an absolute requirement. And I put beware. Under Johnson versus Butterworth, the Florida Supreme Court in 1998 says when a defendant makes only a general request under Brady, it is the state that decides what information must be disclosed. The prosecutor's decision on disclosure is final. So to file a motion and say, I want Brady material, well, then the prosecutor decides what to look into and what to give you. It has to be a specific request in the motion. It has to spell out, I want, all the text messages. I need the emails between the police department and the prosecutor. All of that is not work product. That's all information which should be looked at. And if the prosecutor won't show you, then have him show the judge in camera to have the judge turn it over to you. As an example, the following may be requested for the prosecutor to search for, obtain, and disclose to the defense to exclude work product and privileged information. 1, emails, I just said that. Prosecutor to police, police to prosecutor, state witnesses to police or prosecutor, police or prosecutor to witnesses, lay, and expert. 2, text messages, instant messages. 3, any messages between officers or officer to station. 4, two-way dispatch messages. 5, 911 calls. Pretty easy to get those. 6, audio and/or videotapes, including those captured via body camera or cell phone cameras. I know that discovery requires that, but you need to move for it too. Get a ruling on it. 7, any records stored, sent, or received via Dropbox or similar cloud computing or file transfer protocol websites. 8, all electronic devices, including but not limited to computers, laptops, iPads, cell phones, smartphones that may contain discoverable material relative to the above prosecution. 9, all social media accounts that may bear upon the above prosecution, including but not limited to Facebook, Google, AOL, Yahoo, Twitter, Instagram, Snapchat, and any online cloud backups which may contain information relative and related to this prosecution. 10, all handwritten notes of law enforcement officers to be reviewed in camera for Brady material. Remember, the rule of criminal procedure says you're not entitled to the handwritten notes. Okay, but you're entitled to Brady. So you're not asking that they be turned over to you. You're asking that they be turned over to the court for an in-camera review to see if there's any Brady material. And you can cite the case that I'm going to talk about in a moment. 11, all handwritten or memorialized notes of the prosecutor concerning witness interviews or law enforcement officers, experts, and lay witnesses involved in the above prosecution where questionable Brady material may be located in it, and an in-camera review by the judge may determine the disclosure. Such notes are intended to include but not limited to investigations and trial preparation of witnesses. You know, when a prosecutor, prepares a witness, he's taking notes. Okay, he's taking notes. Notes go in the file. The witness then testifies. Does the witness testify in accordance with what the notes say? Or has the witness changed his statement in a material way? If that's the case, then a material impeachment has to be turned over to the prosecution, to the defense rather. Number 12, any and all medical records, including psychiatric and clinical reports that may have relevance to the above prosecution or to any valid defense, including those covered by HIPAA. I'm going to talk about a United States Supreme Court case in a minute, probably the most recent one where Brady was discussed. And it had to do with reversal on the basis that they didn't turn over a medical record, believe it or not. So we'll talk about that in a moment. 13, any and all electronic devices, including cell phones and computers belonging to witnesses listed by the government, which may contain Brady material. 14, the names and addresses of any witnesses known to the prosecutor that has given a statement to the prosecution or law enforcement that is contrary to the prosecutor's theory of the case, including pre- and post interviews conducted during polygraph testing, as well as any witness or evidence that would support a valid defense. So if it's if the prosecutor's theory of the case is there is no self-defense and there's some information that is contrary to that, it has to be turned over. 15, any favorable treatment of any kind given or offered to any government witness in return for cooperation, as well as any favorable treatment, money, or anything of value requested by a state witness in return for cooperation. Now, this Brady, that request under 15 is covered, as you remember, under 3.220, the discovery of cooperating informant witnesses. But it doesn't hurt to ask for it again. And of course, if you don't ask for discovery, then you definitely want to put paragraph 15 in if there is a cooperating witness. 16, any Facebook postings made by the alleged victim relevant to the case, including those that were taken down but can be retrieved by the government. Make that request ASAP. 17, all contents of investigative files to include all agencies that contributed to the prosecution, that include notes, memorandum, and reports. This also applies to the notes of any witness coordinator. Now, the ABA has a rule, 3.8. Sort of talks, it's a Brady rule, and I'll tell you in a minute why I'm including that. ABA model rules of professional conduct, special responsibilities of a prosecutor, requires a prosecutor to, quote, make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense, and in conjunction with sentencing, to disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor. It provides an escape clause for an in-camera production when the timely disclosure could endanger a witness or otherwise unfairly prejudice the prosecution before trial. But you can file an ABA motion as well and have them respond to it. Would be an ethical violation if they were to not comply with this model rule of professional conduct. So include that along with a more specific Brady motion. Then get them to reply to your granted requests. You file the motion. You go down paragraph by paragraph and have them agree that they're going to look for it. All right, does the defense have a duty to look for Brady? You'll have prosecutors to say, I'm not doing your job. I'm not going to do your job. You do your own job. Don't ask me to go up and down a street and knock on doors to see if they have security video. And they don't have to do that, folks. Brady does not require that. But there is some law out there, and I'm reading now, that suggests the defense has a duty to conduct a due diligence search for Brady by looking into areas equally available to it. No suppression was found when the information was in a source where a reasonable defendant would have looked. Okay, Brady has to do mostly with areas that you don't have access. You may not have access to a police officer's notes. You may not have access to the same thing the prosecutor has access to. But if you want to find something out that's in the Library of Congress, go to the library, okay? Look for it yourself. Don't ask them under Brady to go and tell you whether it's in the Library of Congress. Okay, in the last sentences, or if a search of public records could reveal the same information, there's no Brady violation, okay? Key there, public records. But not so where the material is in the hands of the investigative agencies, not accessible to the defense. That's what I'm trying to tell you. That's where Brady comes in, where they have to give it to you. You can't just go out and find it yourself. It's there, but the other side has it. It has been held that the burden-shifting prosecution argument of due diligence has been rebuked by the U.S. Supreme Court. This due diligence defense places the burden of discovering exculpatory information on the defendant and releases the prosecutor from the duty of disclosure. It relieves the government of its Brady obligations. Our decisions lend no support to the notion that defendants must scavenge for hints of undisclosed Brady material when the prosecution represents that all such material has been disclosed. In a nutshell, a rule thus declaring, quote, prosecutor may hide, defendant must seek, is not tenable in a system constitutionally bound to accord defendants due process. So says the United States Supreme Court in 2004. There's a duty to preserve on the part of the state or the government. Once the police or the state possesses materially exculpatory evidence, there is a duty to preserve it. Destruction may be cause for a due process dismissal. The key here is if it's a material, exculpatory piece of evidence, Okay, it has to be exculpatory, beneficial to the defense, and material, very important. If they can it, if they destroy it, then there's going to be an issue as to whether or not it denies due process, and you can't go forward in a trial because you cannot put forth the very evidence that would prove innocence. What happens when they lose or destroy the evidence before the defense can see it or test it? Arizona versus Youngblood, decided in 1988, holds if the evidence in question is only potentially useful, okay, as opposed to clearly exculpatory, then a criminal defendant must prove bad faith on the part of the police to make out a due process violation. In other words, they have to show they specifically destroyed something like a surveillance tape or something that could have exonerated the defendant, because maybe they looked at it and they say, that doesn't look like the defendant. Let's get rid of this surveillance tape. That's bad faith, and a Youngblood discovery violation will be found. Get the last word. Consider, okay, if you have a situation like that, consider asking for a special jury instruction. It's actually found in the Youngblood case. Ask for it. And it tells the jury, quote, if you find that the state has allowed to be destroyed or lost any evidence whose content or quality are an issue, you may infer that the true fact is against the state's interest. So he's basically telling the jury, if they lost it, there's a presumption it was good for the defense. I've asked people what double blind perjury. Kind of a strange statement. It's not mine. It's talked about by the courts. And it says that due process is violated when a prosecutor makes a deal with defense counsel, but exacts a promise that the lawyer will not tell his client, so that the client can testify that no deal has been given for his trial testimony. And when that occurs, Brady requires disclosure. So when you have a case where a co-defendant is offered a deal, and the prosecutor tells the defense lawyer, all right, I'm going to go ahead and give him straight probation and no time in prison, but I don't want you to tell him that. Because when he's cross-examined, I want to say that there's no deal. And that's called double blind perjury. And it's not only illegal, but unethical. Okay, here's the case I was talking about, a few years old, probably the most recent as far as Brady violations, and it's Weary versus Kane. Weary was the defendant, and Kane was the warden. In Louisiana. The U.S. Supreme Court reversed due to Brady violations, specifically during Brady. And this is what the Brady violations were, just to give you some idea. Number one, the state failed to disclose that a testifying witness told fellow inmates that the state's star witness told him to make sure Weary gets the needle because he jacked me over. That statement was never turned over for cross-examination. Number two, another testifying witness said that the star witness told him what to say and that it would help him get out of jail if he said it. Number three, another testifying witness said on the stand that he was not testifying for a deal, when in fact he contacted authorities for that very reason. But the authorities never told the defense about him contacting them. Number four, as I talked about earlier, about a medical record. A medical record was withheld that could have proven that the facts in the testimony of a state witness could not have happened due to injury. And let me tell you a little bit about the facts here. The victim was supposedly killed, and he was killed, and a state witness came up, picked the witness who had been shot and murdered and was dead, brought him over to the trunk of a car, opened the trunk of the car, put this adult male in the back of the back trunk of the car, and then climbed in the car himself, and the car drove off. Well, there was a medical record that was withheld from the defense, and the medical record said that this witness who said that he did those things had surgery on his knees a very short term before. And there's no way, medical way, he could have picked this man up, brought him, put him in the trunk of a car, and then climbed in the trunk himself. And this denial of presenting the medical record was a violation of Brady. Now, one of the reasons for the Brady violation had to do with exonerating the defendant Weary. Not one of them. But they all amounted to material impeachment of a critical witness. And the defense was entitled to this information to use in cross-examination. So the withholding of material impeachment information was responsible for this reversal. Do you know that you may be entitled to the prosecutor's witness preparation notes? I mean, come on, aren't they going to say when you file that motion, work product, they're not entitled to that, work product. And, generally speaking, it is work product. You are entitled to material impeachment or contradictory statements of a witness so that the prosecutor expects to call for trial. It doesn't matter that it occurs in a prosecution witness preparation meeting. It's Brady, okay? Plain and simple, so ask for it. And here's the case out of the Florida Supreme Court in 1999, Young versus State. A Florida prosecutor was preparing his witnesses for trial in a murder case where self-defense was an issue. Witnesses were inconsistent on whether a shotgun or a handgun was fired first. In this case, the defendant had a shotgun and the police officer a handgun. And the important question was which was fired first. It was a critical fact. The prosecutor withheld his notes taken from another police officer witness during trial preparation that cast doubt on that fact. In fact, it was a trooper, and he said initially to the prosecutor that contained in his notes, he says, when I first heard it, I thought it was firecrackers. But when he took the stand, he said, I know now that the first thing I heard was a shotgun. Well, those notes in the prosecutor's file, which normally would be work product, were never turned over. In this case, the death sentence was reversed for a new penalty phase by the state Supreme Court, citing Brady. And don't forget, Brady was a sentencing case as well, and said that there was an obligation to turn over material impeachment, and they didn't care whether it's in the prosecutor's notes or anywhere, even if it's in protected areas or areas that normally were not permitted to go into. It still has to be turned over. Is inadmissible evidence subject to Brady? The United States Supreme Court basically says no. The prosecution is not required to turn over Brady information in matters involving inadmissible evidence. Okay? Why? Because it's inadmissible. But they are required when the information might lead to admissible evidence. So again, you want to put that in your motion that you may know it's not admissible, but it may lead to admissible evidence if you have an argument for that. And let me spend a minute on Wood versus Bartholomew. 1995 United States Supreme Court case. And this is my point. If the results of a polygraphs are not admissible, we know that. The state may not have to provide them to the defense, okay? That's what the United States Supreme Court says. But what about the pre-test or the post-test interview? Did the subject lie there or change his story as to the offense facts? If it constitutes material impeachment, then it has to be turned over. Let me just spend a minute on this. You don't want to file a motion and say, I understand you put the victim on a polygraph. Did they pass or fail? They don't have to tell you that. They don't have to tell you that because the answer to that is inadmissible. Neither side can put it in. But what you are entitled to, and if you know anything about polygraphs, the polygraph operator spends a lot of time with the person before the trial, before the test starts. He asks them all kinds of questions to get an idea of how the testing questions should be asked. He or she then gives the test. Then there is a post-test interview, okay? If the person does real well, there is no post-test interview, okay? Congratulations, you passed, have a nice day. But if there is a post-test interview, that means you didn't pass. So, buddy, we got to have a discussion here. We got to find out, when I asked you whether or not you took the girl from that bar at 2 o'clock in the morning and you said no, you ain't passing. Now, did you take the girl from the bar at 2 o'clock or not? Well, second thought, yeah, I did, but I only walked her down the street and then I said goodbye. Okay, now all of a sudden we have material impeachment, don't we? So you may not be entitled to the results of the polygraph, but you want to know if there's any Brady material, any material impeachment between the pre-test and the post-test interview. Gold, could be some gold in there. In other words, if you are not entitled to the document, report, or record, you are entitled to Brady material in that document or report. So when the prosecutor takes the position that the records are not subject to disclosure, your response is that you are not asking for the records. You're asking for the information in those records that falls under Brady to be disclosed to you. What should be disclosed? Any information that tends to cast doubt on the defendant's guilt with respect to any essential element in any charged count. Doesn't have to be the whole case. Could be an element that casts doubt. 2, any information that links someone other than the defendant to the crime. 3, any physical evidence, testing, or reports tending to make guilt less likely. It may not exonerate him, but again, if it has to do with making guilt less likely, it might also have an effect on sentencing. The judge may take something like that into account and said, you know, I was going to give you 30 years, but now that I learned this information, I can see why you did what you did. I sentence you to whatever, 5 years. Next, any information regarding the failure of any witness to make a positive identification of the defendant. And, you know, I got to spend a minute on this one. If you've ever seen a photo lineup, they put the pictures down in front and they say, I want you to take your time and tell me whether or not, you know, you see anybody in there that you may recognize, or whatever they say. And they take number 2 and they slide it up. And they take their finger and they slide it up. Then they slide it back down. Then they look down there and they look at number 6 and they slide up number 6. And then they slide back number 6. And then ultimately they end up saying it's number 3. And they sign their name to number 3. Well, the problem with the police report is they're going to say the witness positively identified number 3, which happened to be the defendant, as the person who committed the robbery. Any information, that affects a positive identification, the fact that they lingered on number 2 or number 6 is all to be provided under Brady for cross-examination, because then there can be some impeachment cross-examination of this witness. Any evidence that tends to lessen punishment, we just talked about that. Any information that tends to support an affirmative defense. If they have information that supports self-defense when they know it is a self-defense case, even if they don't know if it's a self-defense case, but they have someone that saw it that way, they have to do it. Same with insanity or alibi. Any exonerating evidence has to be turned over. Exculpatory evidence is defined by case law. Any material impeachment or material inconsistent statements all have to be turned over. There's only one way to ensure Brady compliance. You've got to file a motion. You just have to file a Brady motion. You have to calendar it for hearing. Okay. Number 3, you have to get the court to grant the motion. Okay, the prosecutor, all right, if there's any exempt from public records, okay, prosecutor, review them. Look for Brady in them. If you can't trust the prosecutor, ask the judge in camera to do an inspection and to see if you're entitled to anything. Turn over all the other material requested for the defense review. Then you need to set another hearing for the prosecutor to confirm review of the exempt records and status of all items to be turned over, item by item. Don't go in there and file the motion and in the hopes the judge says motion granted. Don't do that. You need to go one by one, and then when you go, back after the prosecutor looks for this stuff, one by one, have them say, "I looked, it's not there. I looked, there's nothing there," or whatever. But you got to pin them down. Ask the judge for a Brady scheduling hearing to continue disclosure by the government. You may do this early on in the case, and then 7 months later, there's more Brady stuff coming in. So you want to have another scheduled hearing closer to the trial. Let's see, did you come across any other Brady information? Now, this is not going to make the prosecutor happy, but your job's not to make him happy. It's not going to make the judge happy, but the judge will respect you for doing a good job for your client, hopefully. Have the judge rule that any issues as to materiality questioned by the prosecutor should result in an in-camera review by the judge to make the call. Prosecutors sometimes say, well, that's not, I didn't turn it over, Judge, because it's not material. Well, no offense, but it is to me material. And let me show you how I can use that when I cross-examine. So if you think that the prosecutor may make that mental decision of immateriality, then have the judge make the call. Ask for an in-camera review. If they think it's not material, here are the ones we don't think material, Judge. You make the final call. And I can almost guarantee you the judge is going to err on the side of giving you everything. Now, the feds have a memo, okay? I know this is for Florida lawyers and so forth, in state court, generally speaking, as far as the Rule 3.113. But this is important because it tells you, Brady versus Maryland it applies to all 50 states, all federal jurisdictions. It is throughout the United States. And there's a memorandum that was prepared in 2010. It's called Guidance for Prosecutors Regarding Criminal Discovery. And it lists, quote, gathering and reviewing of criminal discovery as it relates to Brady versus Maryland and Giglio versus United States. And it covers where to look, what to review, and making the disclosure. Okay, look at the number one, where to look. Again, I want to beat a dead horse, but they're saying you have to go out and look for it. You can't sit back, prosecutor, and have it come to you, and then you turn it over, okay? So let's look at where they're telling them they have to go and review. In 2010, the Department of Justice provided guidance to all assistant United States attorneys handling criminal cases about their obligations under Brady. In that memorandum sent out to the Washington, D.C. Circuit entitled Memorandum for the Department of Prosecutors, it began by writing department policy, which states, it is the obligation of federal prosecutors in preparing for trial to seek, once again, to seek, which means to go out and find, all exculpatory and impeachment information from all members of the prosecution team. Members of the prosecution team include federal, state, local law enforcement officers and other government officials participating in the investigation and prosecution of the criminal case against the defendant. What this is saying, and you can easily put it is the obligation of state prosecutors as well as what it says here, federal prosecutors, to go out and find Brady and turn over Brady. In the section entitled What to Review, the prosecutor is directed to look into the following, and I put as well as other non-exhaustive areas. This is a multi-page document. I highlighted it by trying to show you what Department of Justice is saying that assistant United States attorneys should be doing in their Brady obligations. One, the investigative agency's entire investigative file, that's what they're to be looking into, including documents such as electronic communications, inserts, emails, should be reviewed for discoverable information. Should sensitive information ordinarily not discoverable be contained within the review document, the entire document is not necessarily discoverable, but only the discoverable information contained in it. See, that statement is exactly what I've been saying. If you're not entitled to the whole document, fine, keep it. Just give me the Brady that's contained within it. 2, confidential informant information should be reviewed in its entirety, including past cases in which the confidential informant cooperated. It should include all proffers, immunity, and other agreements, validation, assessments, payment information, other potential witness impeachment information should be included within this review. Number 3, substantive case related communications may contain discoverable information. In other words, Brady information. They are most likely occur 1, among prosecutors and agents, B, between prosecutors and or agents and witnesses and or victims, C, between victim-witness coordinators and witnesses and or victims. Such communications may be memorialized in emails, memorandum, or notes. Substantive communications, including factual reports about investigating activity, factual discussions of the relative merits of evidence, factual information obtained during interviews or interactions with witnesses or victims, and factual issues relating to credibility. And then there was a note, material exculpatory information that the prosecutor receives during a conversation with a law enforcement officer or witness is no less discoverable than if the same information were contained in an email. So if the lead agent or detective tells the prosecutor something, that has to be turned over even though it was not memorialized. Number 4, the prosecutor should not only look into any benefit that a witness may have in testifying against the defendant, but also known conditions that could affect the witness's bias, such as animosity toward the defendant, animosity towards a group of which the defendant is a member or with which the defendant is affiliated, relationship with the victim, known but uncharged criminal conduct that may provide an incentive to curry favor with a prosecutor, and known substance abuse or mental health issues or other issues that could affect the witness's ability to perceive and recall events. Information obtained in witness interviews, whether memorialized in writing or overheard by law enforcement officers or prosecutors. Any material variance in a witness statement should be memorialized and turned over to the defense as Giglio information. Once again, if the witness is being debriefed and he changes his or her statement, it's the obligation of the prosecutor to put that in writing and give it to the defense. Not just say to the witness, now which is it? Which side do you go with? Which version are you going with? Oh, you're going with version 2? Okay, fine. Let's go with version. No. It's information that can be used for impeachment. Number 6, trial preparation meetings with witnesses are also subject to Brady review. New information that is exculpatory or impeachment information should be disclosed to the defense. So if they're learning it in a private, professional setting, which ordinarily would be somewhat secretive, it has to be turned over. 7, police officers' notes should be reviewed to determine whether or not they contain material impeachment or exculpatory information. Particular attention should be paid to notes gathered during discussions with the defendant or material witnesses. Now there's the Department of Justice telling assistant United States attorneys that they should look at the cop's notes. Now, it's from those notes, of course, that the reports are made. We're entitled to the reports, but they're telling them, look at the notes too. Look to see if there's anything in there they didn't want to put in the report. It didn't help the case. So they left it in the notes, but they didn't transfer it to the report because it doesn't help the government. So when does it have to be disclosed? Okay, the state must timely deliver Brady material to the defense. Timely pretrial disclosure is defined in Miller versus United States as the defense's ability to meaningfully use the information. So it has to be turned over, not the morning of trial, not the day before trial, but in enough time for the defense to say, okay, I've looked into it, I've investigated it, and there's nothing more I need to do. Okay, I'm now ready for trial. So they can't just give it to you the morning of trial. And they can't dump it on you, okay? There are cases that hold the government does not fulfill its obligation under Brady merely by providing mountains of documents to defense counsel who are left unguided as to which documents will be discoverable under Brady. And there's plenty of case sites here. In bigger cases, they end up saying, okay, you see that warehouse over there? That's your discovery. Have at it. Good luck. And you're going to say to the judge, it's going to take me 2 years to read all this. So use these cases to say that they're just dumping it on us. If they've reviewed this stuff, they know the Brady material that I'm entitled to. When can the prosecution withhold Brady? Okay, and it can withhold Brady. Very, 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 very narrow, but they can. Prosecutors may withhold material impeaching information, except exonerating information. One, when the witness being impeached is when the witness being impeached is withdrawn from the prosecution witness list. Okay, unless this witness impeaches another government witness set to testify, then we're back under Brady. But if all of a sudden you have an the prosecutor has an impeached witness and is not going to list him, takes him off the witness list, that's one of the exceptions. The other exception is problematic, and it says the prosecution and the defense are actively, that's my underlining, engaged in plea discussions. So if you're about ready to enter a plea and you're winding the case up and the prosecutor learns of impeachment information, they don't have to provide it to you. And the reasoning was they don't have to provide it because it doesn't look like it's going to go anywhere. It's not going to impeach anybody. It's not going to be a trial. So this impeachment information really doesn't make any difference. I mean, you could argue it'll make a difference whether I'm going to plead or not, but in United States versus Ruiz, it says that if you in plea discussions and you enter a plea and you later find out that the state or the government had impeachment information, you're out of luck. You're out of luck. And if the defense knows of Brady, there's no harm, no foul. Sometimes the defense learns of Brady violations before the trial. Well, a Brady claim cannot stand if a defendant knew of the existence allegedly withheld or had possession of it simply because the evidence cannot then be found to have been withheld from the defendant. And then there's case law supporting that. So Brady violations, if you catch them before the trial starts, they say no harm, no foul, because now you can use it. Now you can impeach. Now you can, look into this exonerating information. All right, Giglio. Let's go ahead and talk a bit about Giglio. A prosecutor may not knowingly offer material false testimony. That's Giglio versus the United States. Giglio on its face may be one of those types of holdings where you say, do we really have to be told that? You have to be kidding me. You know someone's going to commit perjury and yet you put them on the stand knowing they're going to commit perjury? Of course it's going to be a reversal. They ought to lose their license. Well, there are cases involving Giglio that may not quite be as dramatic as that because they might be something that's found out actually during the trial based upon something a witness says on cross-examination that they didn't tell the prosecutor when they were being prepared as a witness. So let's go ahead and talk about the different areas. The last motion to file, after you feel the state has prepared their case and spoken with all the witnesses they intend to call at trial, file one last motion, a motion to disclose Giglio material. The motion should be requesting the state to turn over any and all information which intends to impeach any of their witnesses. This includes inconsistent statements, material false statements, and anything which would contradict a witness's previous testimony or statement to the police or prosecutor. The requested information should not be limited in scope, but rather should include social media, text messages, email, telephone, or in-person discussions. In particular, if there are any material contradictions or impeachment found after depositions have been taken, that would be included in the Giglio material being requested. This is the practical aspect of this Giglio motion. The prosecutor, at least in felony cases, takes sworn testimony of the witnesses to decide whether charges should be brought or not. So that's the first time, other than the police talking to them, that they're grilled by the state and placed under oath. And they state what they remember the case to be and what their testimony is going to be. After that, there's discovery depositions, and the defense lawyer now talks to this witness and finds out not only what the statement is, but whether all the statements he's given, to whom he's given statements, to the prosecutor, to the police officer, any and all statements and times that he has told his version of the story. Is there anything materially impeaching by those particular times where he's spoken about it? And then lastly, when the prosecutor conducts his witness prep before the trial, now we have a third time. Tell me what happened. Let's go over your testimony when you're on the witness stand. The question then becomes, is that any different from the other times that they've made that statement? You're entitled to that. So I would recommend filing a motion to disclose Brady material very close to the trial itself, when the prosecutor has an opportunity to talk to the witnesses, particularly an alleged victim, 2 or 3 times to determine whether or not there's any changes in those testimonies. Let me digress a moment. This happens a lot, and I don't think it's turned over under Brady. It happens a lot. You get witnesses that are not of the greatest caliber. They don't like cops. They don't like prosecutors. They don't like the system. They don't like judges. They don't like lawyers. They don't like anybody. And they got an attitude. But they're necessary for the prosecutor to use to call witnesses because they saw the shooting or the stabbing or whatever. And they're punks. And they come in, they got an attitude. And they initially told the cop, yeah, I saw the guy stab him. Yeah, and this is how he stabbed him and so forth. Well, then they come in and they talk to the prosecutor. And the prosecutor says, what'd you see? I didn't see anything. What did you just say? I didn't see nothing. I was all coked out. I didn't see anything. I don't want to testify. What do you mean you were all coked out? You never told anybody that. Well, I was. I didn't see anything. And, so I'm not going to testify. And then the prosecutor says, let me tell you something, buddy. We went out to your house and we saw the way that your 8-year-old is living. We're going to have a Division of Family Services go up, pick your kid up, take it out of your house. You can't do that. Yeah, watch me. Okay? You want to play games with me? Then I'm going to go ahead and grab your kid and I'll play games with you. Now, let's start over. Did you see anything? Yes. And then he goes back to his statement, and then he says, no, he wasn't coked out. And then he said, all of that information, prosecutors have an obligation to turn it over because it's impeachment information. Didn't you tell the prosecutor you didn't see anything? Let him say I was frustrated, I was kidding, or whatever it is. And then you can go in, weren't you threatened to have your kid taken away unless you went back to the initial story? Yeah. And so you went back to the initial story. Yeah, wouldn't you? But anyway, these kinds of discussions and what they're talking about and what the Supreme Court is talking about is material impeachment. So that needs to be turned over. Young versus State. Remember this case? We talked about it about a half hour ago. The above case holds that normally protected notes taken by the prosecutor during a witness interview must be handed over to the defense if they contain information which is now contrary to what was previously stated or related to the prosecutor as it falls within Giglio. Okay? Material information. I mean, they can't make totally different statements. That falls squarely under Giglio. Who was Giglio? And this is another kind of a Brady thing. People don't understand some of these things, and it's kind of interesting who Giglio was, about as interesting as Brady. A key witness for the prosecution testified that he and Mr. Giglio forged $2,300 in money orders and that he still could be prosecuted. That's what he testified to in court, okay? The prosecutor argued in closing that the witness received no promises that he would not be indicted and therefore he should be believed. But in fact, the grand jury prosecutor, which was a different prosecutor, had, unbeknownst to the trial prosecutor, promised the witness that if he testified before the grand jury, he would not be indicted. The trial prosecutor denied any knowledge of the promise. He didn't know about it. And thus any knowing and using false testimony. He says, this isn't a violation because I didn't know that the other prosecutor had offered him immunity. I thought he was telling the truth when he testified that he was testifying for no negotiation or deal. But the United States Supreme Court imputed the promise of the first prosecutor to the entire office and reversed the conviction. So even though the trial prosecutor didn't know that his witness was testifying falsely, it was imputed to him because someone in his office had made that promise that he would not be. Kind of almost a double-blind perjury type of situation. And so, Giglio cried foul and said that's something that he could be used for cross-examination. And the Supreme Court, made it very clear that if it occurs in that office, it's going to be called up. Giglio violations. Okay, a Giglio violation is demonstrated when it is shown, 1, the prosecutor presented or failed to correct false testimony. Okay, I underlined or failed to correct. This is what happens most of the time. I don't think you're going to have an awful lot of prosecutors that talks to someone before they put them on the stand and say, now listen, I know you're going to lie, okay, but it's the only way we're going to win. So I want you to go up there and lie, and then we'll both deny it if you get caught. I'd like to have a little bit more faith in the system. But what happens is these people then take the stand, okay, after having told the prosecutor what the testimony is, and they get rattled or they get annoyed by the defense lawyer, and they want to get back at the defense lawyer. So they ratchet up their testimony and they add stuff that they never told the prosecutor that's contradictory to what they told the prosecutor. So if the prosecutor is sitting there listening to it thinking, where did that come from? Holy smokes, I specifically asked him that and he told me this, and now, it's helping me, but, this is definitely false testimony. So what the holding is, if you fail to correct it, even though you don't know it's going to happen, but it happens in front of you, it's a violation of Giglio. Number 2, the prosecutor knew the testimony was false. Well, as he's listening to that, he knows it's false because he flat out asked him that very question in witness preparation. 3, the false evidence was material. Okay, there are a lot of cases that talk in terms of, if one witness says one thing and another witness says something completely different, that's not a Giglio violation. It might be the way that each witness saw the particular event, even though it's 180 degrees apart from each other. So it's got to be a definite material false statement that really has no explanation other than the fact that it's perjurous. Huggins versus State, Florida Supreme Court, 2014. If a defendant claiming a Giglio violation successfully shows the state knowingly presented false testimony, the state bears the burden of proving that the testimony was not material by showing that, and then this is my underlining, there is no reasonable possibility that it could have affected the verdict because it was harmless beyond a reasonable doubt. Now, if you compare that against a Brady violation and what it takes for a reversal of a Brady violation, you'll see that Giglio is ratcheted up. Presenting false testimony just destroys the very fabric of our judicial system. So if there's no reasonable possibility it could have affected the verdict because it was harmless beyond a reasonable doubt, is pretty high for the state to be able to overcome. Knowing refers to knowing beforehand as well as learning of the falsehood while the witness is testifying or changes his or her story on the stand. So it's knowing beforehand, knowing during testimony, or frankly, even after the person leaves the stand and the trial is over. A Giglio violation could really be be present and a requirement by the prosecutor to come forward if he learns after the trial that perjured testimony was used to obtain a conviction. And Florida Bar has an ethics rule on this, really. It's kind of a Giglio ethics rule. A lawyer shall not offer evidence that the lawyer knows to be false. That's Giglio. A lawyer may not offer testimony that the lawyer knows to be false in the form of a narrative unless so ordered by the tribunal. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. A lawyer may refuse to offer evidence that the lawyer reasonably believes is false. All right, let's talk about some of those areas. It says that a lawyer may not offer testimony the lawyer knows to be false in the form of a narrative. You know what they're talking about there? That's when the lawyer is the criminal defense lawyer is told by a defendant, I'm going to get up there and lie. After listening to this whole trial, all I have to say is such and such. It isn't true, but if I say such and such, if I explain why that DNA is where it is, and that's all they had, I have a good explanation for that. It's not true, but I'm going to get up there and say it. Lawyer's obligation is to try to dissuade him, to tell him it's unethical to do that, it's against the law to do that, it's contemptuous to do that, and so forth, in the hopes that you can dissuade him. If you cannot dissuade him, then it's the lawyer's obligation to ask to approach the bench outside the presence of the jury and say, my client wants to testify in this case, Your Honor, and will be called as my last witnesses. But at this time, I would move to withdraw as his counsel. That's going to be a red flag to the prosecutor and the judge. And they'll probably know exactly what you mean. In the history of the world, that motion's never been granted. And so you stand back, you call the defendant to the stand, you ask his name. Are you the defendant in this case? Yes. And do you have a statement to make to this jury? And he does a narrative. You don't ask him question and answer. It's a narrative. When you think he's finished, you say, are you finished? Yes, I am. Your witness. And you turn the defendant over for cross-examination. And the last thing is, in the final argument, you may not discuss the witness's testimony, your client's testimony, because you would be giving it the benefit of truthfulness if you did. So you have to stay away from that. The remedial members, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. I think maybe that's the next slide about what are remedial. What exactly are reasonable remedial measures? Let's take a look. You bring it to the court's attention, and that's what the rule indicated, and that's what Giglio talks about. You stop the proceedings. Your Honor, I need to come up to the bench. And you might want to ask that the jury be taken to the jury room. And you bring it to the court's attention. Your Honor, this witness, and I'm not talking about your client now, I'm talking about a witness, or the prosecutor has to do this, and bring it to the court's attention that there's material impeachment information that you believe falls within Giglio. So you bring it to the court's attention. You bring it to opposing counsel's attention. You may want to do number 2 before you do number 1. I don't know. If the witness changes his or her story on the stand, approach the bench or ask for a recess, then disclose what you know. Always try to dissuade the witness from giving false testimony before they testify if you suspect that they will. Hernandez versus State, Florida Supreme Court, 2015. Mere inconsistencies, and this is what I was talking about earlier, in a witness's statement or differences in their testimony given at different times are not sufficient for a Giglio violation, nor witnesses that contradict each other. In the Giglio contest, the suggestion that a statement may have been false is insufficient. The defendant must conclusively show that the statement was actually false. So that's a somewhat of a higher burden. It has to, flat out leave no doubt in the minds of the judge that you're lying. You have committed perjury. Not just inconsistent on, I think his shirt was off red. Now I think it was purple. That's not going to cut it. It has to actually be false. The test for materiality under Brady and Giglio, I kind of hinted by this before, they are different. Under Brady, the non-disclosure evidence is material. If there is a reasonable probability that had the evidence been disclosed to the defense, the results of the proceedings would have been different. Okay? Whether it's sentencing, a lesser included offense, or what, would have been different. Under Giglio, the prosecutor's knowing use of perjured testimony or the prosecutor's failure to correct what he or she has subsequently learned was false testimony is material if there is a reasonable probability that the false testimony may have affected the judgment of the jury. So you can see the difference in materiality and what is required for a Brady and a Giglio violation. Okay, there's me, at least my email address, dennis@devlaming.com. Your host today. We'll leave it up for a moment. If you have any questions you want to ask me about this particular seminar, you can go ahead and shoot me an email. Be happy to answer them if I can. I've been going around the state giving Brady seminars to try to tell criminal defense lawyers whether they've taken 3.113 or not, the obligations of the prosecution under Brady, in the hopes that the defense bar becomes proactive and not just sit back and waiting for Brady information to come to their office, but rather requiring the prosecutor to go out and look for it. Hope you learned something. The rules of discovery need to be followed. Brady and Giglio need to be followed as well. So hopefully I've given you some pointers that when you take back to your practice, you become a better lawyer, whether prosecution or defense. The reputation you earn ethically is the one that you will carry throughout your career. So good luck in your career.